if we look at the Bill of Rights, we get a very clear sense of what sort of things these people at that time, this is approximately 1790 in America, we get a very strong sense of what their concerns were, what their fears were. And I think a lot of those fears were fears about the potential for the abuses of a powerful government. And what we see is a lot of these amendments have to do with your legal rights, and especially the rights you have if you're accused of a crime or if you're being investigated for a crime. Amendment 4 about against unreasonable searches and seizures, the idea that the government does not have the right to invade your property, to search your house, or to look into your private effects without a warrant, that is, without some kind of justification. Amendment 5, in which you cannot be compelled to testify against yourself. These are all things that really would only apply if you are either a defendant in a lawsuit or a criminal case, or you're being investigated for such. If we look at Amendment 6, the right to a speedy trial. Amendment 7 has to do with lawsuits. Amendment 8 has to do with bail. A lot of these things are really the kind of protections that we would want if we have been accused of a crime, or we've been sued, or we are being investigated. So those, interesting, that is this notion that if generally speaking, the Bill of Rights is setting the limits to governmental power, that the crucial place for the individual when they need to be protected is when they are accused of a crime. So I would say very interesting. Right? The other amendments that I think immediately catch one's eye, if you're reading as a modern person, you're looking over the Bill of Rights, I would say the other amendment is the Second Amendment having to do with guns. Because in America, there is no more contentious and difficult issue, especially in contemporary America, which is terrorized by guns. There's no question about it. This Second Amendment, the so-called right to bear arms, it's very, very difficult to interpret. I mean, let's look at the Second Amendment. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I think if you are pro-gun, let's just put it baldly, if you're pro-gun, you tend to look at the second part. If you're anti-gun or pro-gun control, you tend to look at the first part, right? That is, the second clause says the right of the people to keep and bear arms shall not be infringed. And that seems like what it says is that your government can make a law limiting people's access to weapons, to guns, to arms. But if you look at the first part, it looks like there's a qualification where it says a well-regulated militia being necessary to the security of a free state, the right of the people to bear arms shall not be infringed, where it seems to be suggesting that the whole point of having this amendment about arms, which is basically guns, is that we need an army. So, people have to have guns so we can form militias if we need to fight a war, which would seem to imply that the kind of free access to guns we have today is not what they imagined. So the Second Amendment, there couldn't be something more, I think, fundamentally ambiguous, and something that, no matter what side you are on the gun control issue, seems to be fundamentally ambiguous. That is, I think, the people who are for gun control will tend to really emphasize that first part, where it seems to imply that the reason that we're talking about the freedom of access to arms, to guns, is because we need a militia. And that's what they had in those days, mostly, right? Not an official standing army, but a citizen army. And those citizens needed to have guns. to serve in that army, right? Which would imply that free access to guns in general is not what they had in mind. But those people who do want free access to guns would quote it and say the right of the people to keep and bear arms shall not be infringed. So there couldn't be a statement that required more judgment on the part of a reader to figure out what the heck they actually meant. And that's the problem with probably with every general rule of any substance, is that it takes a certain amount of judgment. Judgments need to be made to interpret it, and there are varying judgments. There are competing judgments.